Yeah, shouldn't be any problem. Steve. Steven. Steven. Steve. Does she have the YouTube connection set up? Yes. Is everything connected? She disappeared. I think maybe she did. I just want to make sure before I call the meeting to order.
Yeah.
I mean, I guess I could find out myself.
In terms of acreage,
She came in. It got quiet in here. There's no video showing. It says it started, but it doesn't show any video. Did it get disconnected? Everyone would please rise. We'll call the meeting to order. We'll start with the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right. May I get a roll call, please?
Alderman here. Alderman Campbell. Here. Alderman Flores.
Here.
Alderman Galloway.
Here.
Alderman Gardner.
Here.
Alderman Steiner. Here. We have 6 Alderman present. We have 4.
Perfect. So everybody had an opportunity to review the minutes of May 2nd, 2022 regular session. And if so, are there any amendments or motions to accept? Motion was made by Alderman Campbell, seconded by Alderman Gardner to accept the minutes of May 2, 2022 as presented. All those in favor? That is unanimous. All right, we have no ceremonial or scheduled visitors. We'll jump right into bills. Mr. Flores.
Your Honor, I move that we place Bill 3353 on its first reading by title and subscription.
Motion was made by Alderman Flores, seconded by Alderman Campbell to place bill number 3353 on its first reading by title and description only. All those in favor?
An ordinance amending the zoning code and official map by changing the zoning classification of certain property bordered by South 19th Street to the east and south.
All right. Mr. Childers or Mr. Smith? Which one? Right on. All right. All right, sir. The floor is yours.
Yes, the applicant has requested to rezone an existing parcel that's PUD. The request is to zone it R1D. The property is approximately 41 acres in size. It is currently vacant at this time. The R1D zoning would allow for single-family residential lots of 7,000 square feet or greater. There are no overlay districts of the zoning ordinances that affect this property. There is an identified trail corridor in that That has been noted to the applicant, and they're going to plan to dedicate a trail easement through the property with the plating of this parcel. There are environmental features of wetlands and riverines that are identified on this parcel and shall be further reviewed and permitted through the appropriate agency. The existing water and sewer system has capacity and shall be extended to this project by the developer to serve their development. The applicant has been coordinating with the road district, Ozark Special Road District, and the city of Ozark for future improvements along 19th Street. The comprehensive plan does note the property with a future land use of mixed use. Basically, that is due to the surrounding uses and the current zoning of PUD, which would have been a mixed use scenario. The proposed use that they are proposing, single family, is in conformance with those surrounding uses and also with what was originally proposed in the PUD. Based on staff's report and staff's findings, staff did recommend approval of the commission, and the Planning and Zoning Commission also recommend approval as well. Happy to answer any questions.
Mr. Gardner?
I'm just curious, it was previously zoned PUD.
Yep.
I'm just curious why they wanted to change, because they could do the same thing in a PUD.
Yeah, when staff went back to research back, I believe in 2007, the zoning was approved as PUD, but the actual PUD document was never approved. There was some commission, the Planning and Zoning Commission had comments to the applicant. They made some revisions, brought back to the commission again. There's additional comments. And at that time, it never was brought back forward to the commission, so it just died. So we kind of have a non-conforming zoning out there without a legal document to go with that zoning of PUD. Since they're requesting a straight zoning on this parcel and a zoning on a neighboring parcel, we just went with the straight zoning as opposed to re-adopting a PUD ordinance.
Very good, thank you.
Any additional questions from the board? Is there anyone in the audience here this evening that would like to speak on this topic? You just deliver your name and address to the clerk here.
Thank you. Clayton Hines. I'm with Schaefer and Hines. P.O. Box 493, Nixa, Missouri 65714.
Yes, sir.
Thank you, guys. I don't really have a big speech or anything. I'm just here to let you know that we worked on this for the ownership group, and Miss Julie Tobash is representing the ownership group here as well, and be happy to answer any questions. We worked hard with staff to go through everything. If you guys get questions, I know there's 3 of these that kind of pertain to this. I don't have a big presentation at all, but if you have any questions now or as you deliberate, I'll be happy to answer them.
Okay. Does anybody have any questions?
Okay. Thank you.
You're very welcome. Anyone else here to speak this evening? Go ahead and come on forward. You give your name and address to the clerk, please.
Jeannie McFall, 1324 East Warren Avenue, Ozark. I just had a question, and this will apply to the other zoning too. Since the plan unit development is getting changed to a single family or multifamily, what would happen if somebody else has a plan unit development and wants to change that in the future? Will they be allowed to do that if they have some land that hasn't been completely built on?
Do you have an answer for that, or do you want to defer to the attorney?
If at a later time, the applicant does choose to request a PD rezoning, they could come back before the commission and board to request that for approval. They would request the zoning along with supplying that PUD document, that text bound document kind of identifies their property restrictions. So there's nothing that prevents them from doing this in the future.
I'm referring to something that's already a plan unit development and wants to go the other direction.
Okay, so the
Not
opposite.
this particular property, but just for future, is that allowable?
I guess I'm only speaking in this property tonight. If there's something else, a different application, we just have to evaluate if they want to go to a PUD or a different zoning at a later date.
Okay, so her specific question though was, if there was a PUD on the books that wanted to change and go back to a specific zoning classification, would they be allowed?
Are we talking about this application or different? Because if it's a different
This is a
application,
hypothetical situation.
it's case by case. We're only talking about this one tonight. This one they could if they choose to come back at a later date.
Mr. Childers?
I always like to jump in on these. Yeah, I think anybody anybody would be allowed to make a request such as that. I mean, if you have a zoning designation, you're certainly welcome to come before the Planning and Zoning Commission and request a rezoning of that property. Now, whether or not that would meet the goals and objectives of the comprehensive plan or the future land use map or any of those things, all of those things would be weighed on a case-by-case basis, as Mr. Smith said, by the Planning and Zoning Commission before it ever came to the board with a recommendation. So I think anybody has the right to request that and go through the process, certainly. But again, you just kind of base that on a case-by-case basis.
Okay. Is there anyone else in the audience that would like to speak on this evening? All right, hearing none, there's no one on Zoom, so any other comments, questions, concerns from the board? Hearing none, this bill will be held over till the next legislative session. Mr. Flores?
I move that we place bill 3354 on its first reading by title and short description only.
Motion was made by Alderman Flores, seconded by Alderman Campbell. Place bill number 3354 on its first reading by title and a short description. All those in favor?
An ordinance amending the zoning code and official map by changing the zoning classification of certain property bordered by US Highway 65 to the west and South 19th Street to the south.
All right, Mr. Smith.
Yes, this application is for the second parcel of the applicant. This particular parcel, they are requesting the R2 zoning for a two-family use. The property is approximately 16 acres in size, and again, is currently vacant as well. The the R2 zoning is what they're requesting. The property shall conform to the 65 overlay district as it is affected by that overlay district. There is no identified trail corridor on this property in the OTO land or trail plan. However, they are identifying that trail on their other parcel. There are environmental features, and as such features, they shall be further evaluated at the appropriate time for permitting by the appropriate agency. The existing water sewer system does have capacity and shall be extended to this property as well by the developer to serve the development. The applicant has been coordinating with the road district and city as well for those future improvements. Most of those improvements will occur with the other parcel of land and more affected there as it abuts the 19th Street corridor. The comprehensive plan, similar to the previous application, does note this as mixed use. The two-family residential would accommodate those surrounding uses and the comprehensive plan and the proposed other single-family use. Based on the staff reports and staff's findings, staff did recommend approval. In addition, the Planning and Zoning Commission recommended approval as well. Be happy to answer any questions.
Does anybody have any questions for Mr. Smith? Hearing none. Yes, sir. Sure, go right ahead.
Don't we have, just so everybody knows, we do have PUDs that are allowed to have all residential now, right? We used to have a PUD designation that where you had to have a mix, but now I believe that you can have a mixed use residential only PUD.
Yeah. It's either mixed use or mixed density.
Oh, mixed
So they could
density.
have single family with set like the R1A, B, C, D, different densities of those.
Thank you.
Okay. Is there anyone in the audience here to speak on this bill this evening? Hearing none, there's no one on Zoom. I'll give the Board of Aldermen one last chance on this first reading. Hearing none, this bill will be held over till the next legislative session. And again, Mr. Flores.
Move that we place bill 3355 on its first reading. Short description.
Motion was made by Alderman Flores, seconded by Alderman Campbell to place bill number 3355 on its first reading by title and short description. All those in favor?
An ordinance approving the preliminary plat for Valley Ridge Estates and authorizing the Director of Planning and Development to accept the dedication of the public streets and easements to the city as shown on the preliminary plat upon the applicant filing and recording a final plat that substantially conforms to the preliminary plat, and authorizing the city clerk to sign the final plat upon compliance with the terms of this ordinance.
All right, Mr. Smith, once again.
Yes, this application is for the preliminary plat for Valley Ridge Estates for the previous two zoning applications. The proposal has approximately 105 single-family residential lots and 35 R2 lots. The preliminary plat proposed does conform with the requested zoning that they have on the agenda this evening. The preliminary plat, like I stated before, does identify a trail corridor which would go along the, if you're looking on the screen, the upper side, there's kind of a green belt that goes through there that's kind of the natural drainage way of the property. Once the water and sewer plans are completed and designed, staff will further review and evaluate that design with our third-party engineers as well for conformance. And the applicant, like I stated before, is working with the Ozark Special Road District and the City of Ozark and has had the initial approvals of those connections to those streets and based off the preliminary engineering report for the traffic impact. Based on staff's findings and staff's approval or recommendations, staff did recommend approval. In addition, the Planning and Zoning Commission recommended approval as well. Be happy to answer any questions.
All right. Mr. Campbell.
I may be misunderstanding this, but when I look at Bill 3355 at the zoning map, it looks to me like it's actually identifying the other parcel that doesn't have the trail.
I think it's just a depiction of that exhibit that was in there. It should be both of those. This bill is for both of those two zoning applications.
Okay, so it covers.
It covers both. That's just a, but not a typo, but an error in exhibit.
Okay.
Any other questions from the board? Is there anyone in the audience here to speak on this bill this evening? Yes, ma'am.
Jeannie McFall, 1324 East Warren Avenue. I just had a question, since this is part of the transportation district, is Ozark Special Road District getting part of the money for that, for 19th Street? And are the people in this subdivision going to have additional property tax on their property with the transportation district?
Which one of you guys want it? Go ahead, Mr. Childers, go right ahead.
That's a good question about 19th Street. We just recently went through working with the Ozark Special Road District on a brand new map. So that section is now going to be under the responsibility and ownership of the City of Ozark. So we will be responsible for 19. So the TDD will be able to be utilized for maintenance of that roadway. But as a second question about additional property tax, no. The Ozark Center TDD is a sales tax and not a property tax. So there will not be any additional taxes on the real property.
But if I shop at Lowe's and at Walmart or any of the restaurants in that area, I'm paying for the city streets in this subdivision?
You're paying for the projects that the Ozark Center TDD has adopted by the courts to complete. So just as the TDD has been in place for, I don't remember when it first got in place, 15 years, a new set or a new list of projects have now been adopted, and any additional infrastructure would be eligible to be maintained by the revenues generated by the TDD. So
the only reason I bring it up is I was at the meeting when Walmart was approved, and our interpretation was once they got their money, then the tax would go away. You know, you guys renewed it for future projects, but this is different for a residential subdivision. So that's just a concern I have.
thank you.
All right. Anyone else in the audience here to speak on this topic this evening? All right. This bill as well will be held over till the next legislative session. Mr. Flores.
Move that we place bill 3356 on its first reading by title.
Motion was made by Alderman Flores, seconded by Alderman Campbell to place bill number 3356 on its first reading by title and brief description only. All those in favor?
An ordinance amending the municipal code of the city of Ozark, Missouri, chapter 407 signs.
All right.
Yes, I'd like to go through the ordinance and the revisions with you this evening. Just to hit a few of the highlights of what these revisions include: wall signs on exterior buildings, on-premise highway corridor signs, freestanding signs often referred to as billboards, off-premise directional signs, and following the end of this, we'll go over the Reed versus the town of Gilbert case that has spurred a lot of these revisions that we have this evening. A lot of these revisions do offer some more flexibility. In some cases, it does reduce some of the requirements in regards to signage. So if you're flipping through the ordinance, we'll go directly to page 4, kind of starting those revisions. Ideological non-commercial signs, we are removing that definition from the ordinance due to the content base and some of the exemptions of those signs. We no longer feel that it's needed in the ordinance. Further down the page, monument sign, we've added a definition for a monument sign as it complies with the off-premise directional sign. Since we're adding that or proposing that in the ordinance, we need to define what a monument sign is because we didn't have that in the past. And then the last definition there, the off-premise outdoor advertising sign. In some cases, the ordinance referred to as the off-premise sign, some cases called an outdoor advertising sign. So we're just trying to clean up that verbiage just to be consistent throughout the ordinance. Listen, if you don't mind, I'd like to go through everything, and then once we get through everything, we can go back and kind of address some of the questions. I don't mind if you which one did I skip? Probably did. Well, I guess I tied it with the monument sign. So with the new proposed off-premise directional sign, we are adding a definition in here about what that is. And then above that is the monument sign to further clarify that. So it is a new definition because of the proposed off-premise directional sign that we do have in the ordinance.
All right.
Moving on to page 5. The outdoor advertising sign, again, just because of the redundancy and combining it with that other definition, we removed that from the ordinance. The political sign, it is one of those that will come up from the Reed case. It is a content-based type sign, so we're removing that and are treating those as a temporary type sign and later on the ordinance. Again, the second definition further down the page, real estate sign. Again, that's a content-based sign, so we're redefining that later on in the ordinance for clarification. Moving on to page 7, at the top of the page, there was just some additional language that staff added in regards to a permanent wall sign along any property frontage as opposed to just a street frontage. On page 8, in regards to the permits required, it addressed the fees in the ordinance. It's an old reference that was used prior to adopting a fee study. So we're just updating that reference. So we just note it's on file for our yearly fee study that gets adopted by the board. Further down the page under C, just the directional promotional sign, that was just an unnecessary language that staff felt in that note, and so we removed that.
He's wanting to go through everything and then
I
answer all questions.
I don't want to get derailed like a previous ordinance. We got to page 2. On page 10, the outdoor advertising sign, again, there's a redundancy there because we further identify that in the ordinance. Moving under exempt signs, we are striking the language in regards to the flag of a government or non-commercial institute and the religious symbols and such. Due to those are unnecessary items identified, and they're not considered a sign in our ordinance. And then further down the page, number 6, similar situation, but again, it's further identified as a temporary sign later in the ordinance. Moving on to page 11, this is where we kind of get into more detail. The wall signs, we've had a non-legislative meeting a couple times on this to further define these. But what staff was finding, and kind of recap the previous discussion on those, in 2006 of the sign ordinance, we allowed wall signs on all sides of the building. In a later revision in 2009, that was removed. Not sure why, but it had been continued to be interpolated as allowed on buildings without a street frontage. So what staff is proposing is to put that back in where we can permit a sign on all sides of a building regardless if there's a street frontage or not. However, if it's a non-street frontage, we've taken some old language and just it would be a reduce in size, a reduction in size in those situations. So again, under that page, under that at the bottom of page 11, we're just further defining the wall signs and allowing those on all sides. On page 12, item number C there, again, we just combined that with the item on the previous page and it's an unnecessary information in the ordinance. Moving on to page 13, the off-premise directional sign. This is a section that kind of further defines where these can occur, the size of these signs, and such as the location along what corridors of the transportation road networks. Moving on to page 14, the maximum height that's of the off-premise outdoor advertising sign. Staff was seeing a lot of requests for variances on the heights of those signs. A lot of the existing signs exceeded that 40 feet. So we're proposing to allow that to go up to a 70 feet in height for those off-premise signs, such as billboards, if you want to kind of give it a generic term. Moving on to page 17, the yard or portable sandwich sign, that used to be under our temporary signs. We've removed that and put it under its own section for further clarification because they're a little different because a lot of these sandwich board signs occur around the downtown and square area. I really want to clarify though, under the title there, it previously was noted as no permit was required. We mistakenly removed that language. However, we don't plan to require a permit for those. So we will go back and add that language in for the final ordinance, just to clarify that no permits required for these signs. That's on page 17. Yeah, I'm going fairly fast. Yep. And then again, under this language, it's all underlined, but it's the language removed since we stricken it out of another section. Added here, it's an underlined language. Moving on, page 16, permanent mobile signs. We're proposing to remove these completely from the ordinance regarding any mobile signs. Previously, there was no permit required. We don't really get into a lot of the specifics of these signs when they're on a vehicle or trailer moving around. So staff is just proposing to remove those from the ordinance completely. On page 18, allow temporary signs. This is where we kind of revamp that temporary sign to kind of accommodate the Reed case and to address the existing signs. Basically, we're clarifying that we are addressing these signs not based on the content. They're treating them all equally, regardless of what they've got on the sign. We're allowing these signs to occur within an event. So before an event, they've given a grace period that they can start before whatever that event is, and then they've got to be removed after a certain date of that event. Under these signs, the types of signs, banners, again, we've addressed the banners in these signs. We have given some allowances on those. I know real estate signs is one of those that gets a lot of discussion and concern. We've revised kind of the verbiage, how these are referred to. And basically, number 3 proposes signs placed on property actively for sale or lease, as may be evidenced by the property's listing in the listing services. So instead of calling these real estate sign, because that is a content-based sign, we're renaming those to a listing of sell or lease. And then under that section, it does address those. With this, there was a discussion or concern about home show, or not home show, but a home showing sign or directional sign. Those actually are not included in this section. They're considered under our sandwich board or yard signs. Those are what's called like a poke in the ground sign. So those are already covered in under that previous section that we removed out of the temporary sign and made its own section. So no permits for those are required, but they are accommodated in that section. Moving on, development and construction signs, we just stricken the language of development and just left it as construction signs because it's just repetitive information. And then the item E under that, those will be considered more of an in the temporary sign scenario. Moving on to page 20, temporary signs shall not be permitted. We've added this information just to clarify because it's not a permitted type sign. It's just more of a temporary sign that we're not allowing certain cases of these to occur. In the past, we've never allowed signs to be on a utility pole or in right of way and such, so we just got the additional information in there to accommodate those. In addition to the banners, string mills, and pinwheels, those generally are prohibited in certain, except for certain situations. Again, kind of back to the real estate sign, you'll see that that language is stricken because it's been moved over to a different section in the ordinance. And the items B and C were the two concerns about kind of those off-premise directional type signs or a home showing or signs placed. Again, they're not allowed to be in right of way. And the ordinance prior said that they couldn't be in the right of way. They've got to be on private property, and it's up to the person putting those signs in there to get the approval of the property owner for placement of those signs. Moving on to page 21, again, stricken the information about banners, stricken the information about vertical infrastructure sign, civic signs. Those are all being covered in our proposed temporary sign section. On page 22, again, the yard/and/or portable sandwich sign, those are covered in its own section in the previous ordinance. And then at the end of that page, political, ideological, non-commercial signs, again, we're removing that and just considering those under our temporary sign language instead of addressing those based on the content. And then on the last page, page 23 of the revisions, it's back to the temporary mobile signs. As I addressed before, we're just removing those completely from the ordinance so that we're not addressing those at all in the ordinance. We're restricting those. With that, I'd be happy to answer any questions. Oh, actually, do you want to, I was going to turn over to Ms. Cal.
Yes, ma'am.
Just briefly, I'll walk you through the Reed versus Town of Gilbert case and how it impacted some of the proposed amendments. So as Mr. Smith referenced, a majority of the temporary sign section was amended related to the Reed versus Town of Gilbert case. As a result of Reed, non-commercial signage regulations that are content-based should be avoided. Government regulation of speech is content-based if a law applies to the type of speech based on the message that's being given. So the amendments related to the temporary sign section create some uniformity. There is now a uniform time frame for temporary signs. They may be displayed 60 days prior to the event and must be removed within 15 days after the event. Previously, in the stricken language, you will notice that, for example, civic signs could be put in place 30 days prior to the event, but political signs could be put in place 60 days prior to the event. So this makes those regulations uniform. No permits are required for any of the temporary signage. Previously, some of the temporary signage had to have a permit, which others did not. And so that was a difference based on the content of the sign. And we tried to focus more specifically on the types of signs, such as banners or vertical infrastructure. So most of the regulations under the temporary sign section bring the law into conformance with the Supreme Court precedent related to signs, as we know.
Mr. Gardner.
I've got just some clarification questions. This is kind of confusing when it was to me when I read it for the first time concerning real estate signs. Oh, I'm going to be all over the place. When I get to a specific question, yeah, I'll tell you. Regular yard signs, real estate yard signs, I understand that with the permission of the owner, they can be on the private property. The question I have, and you said something that I'm not sure I understood you. Typically a directional sign or an open house sign are put in right of way because they're on a corner where they're visible. And that's been done for years, whether it's legal or not. But I understand, but you just got through saying something that was handled in the same section as an umbrella sign or a tent sign. And those things are put in right of ways all the time.
What signs?
Tent or umbrella, like a menu sign, like we're having barbecue brisket today, or
Sandwich board sign.
sandwich boards. Thank you.
Sandwich board signs are one of those that is addressed to be allowed in right of way on sidewalks. For example, downtown around the square, because that's public right of way and it's the sidewalk. And so they're a sidewalk sign. So those are, yes, those are addressed in here. And there's a reference to an accessibility code for making sure you maintain the proper thoroughfare for pedestrian travel.
Okay.
But those are allowed on the right of way of the sidewalk.
So if a sign that typically you just step in, a stake sign where you'd step in and it would go in the ground like on a corner where there was a yield or a stop sign, those are not allowed. But if I had a sandwich board sign, I could put that in the same location and it would be allowed?
Basically, if you, in reading that, if it's a sidewalk situation, it's in regards to a sidewalk situation.
So if there's a sidewalk in that right of way where I want to put a directional sign or an open house sign, I can. Question.
I think what you'll get into there is, in those cases, it will not be city right of way, and we can't allow for anything there, and that would be based on that road jurisdiction's requirements. But our ordinance would not accommodate those in that situation because it's a sandwich board sign for the kind of the downtown area.
Is it strictly for the downtown area or only because the downtown area is primarily the place where they're used?
That's primarily where we see those, because in non-downtown areas, there's not a public sidewalk. It's private sidewalk in front of that business.
So sandwich board signs are allowed on a sidewalk only.
Yeah, and again, it's at that business. So again, if you go outside of the downtown, chances are that business doesn't have a public sidewalk right there in front of them. They're actually disconnected from.
So it's on a sidewalk, but it's basically in front of that person's business.
Yes.
So putting I mean, obviously I'm concerned about the real estate side of this because it's been something that we have used for a long time. And a good point, Village Park, if I have a property for sale anywhere in there except that front row of streets, I mean, it's typical, of not just me, but any realtor would. They would put an arrow sign that lets somebody know, or an open house sign if it's going to be open.
Yeah.
So basically these are prohibited because they're in.
That example, it hasn't changed from what we had in the ordinance before. We're just putting those under there as the yard sign. Again, that said that they are allowed off-site, just not in right of way. It has to be on private property with the owner's consent. So we're not changing any of that verbiage. That's the same as it.
So it's been that way for how long?
I couldn't tell you.
A while.
Yeah.
The date and time. That's
I imagine it's been longer, but yeah, 2014 was the last revision. I suspect it was in their prior revisions, but yes, that language was in there before. And that language is on page, if you go to page 20, it addresses it on 2B. Outdoor off-premise advertising signs shall not be displayed, placed, or mounted in public right-of-way or on private property without the property owner's permission. And I guess Ms. Callaway is right. That one actually has the 2014 date on there when that was.
So it's been in effect for some time.
Yep.
Okay.
I vaguely remember that.
Page 20, yes.
I was on council at the time. I vaguely remember a conversation about an equity of signage. Some, real estate signs are in the right of way, but other businesses wouldn't be allowed in the right of way. Why is that equitable? I remember that conversation. You don't have the Pizza Hut sign with an arrow pointing down the street to Pizza Hut, but you have the real estate sign with the arrow pointing towards the home.
Yeah, but in that example, Pizza Hut or any other destination place is going to be pretty well known and seen. Where these are beneficial is when they're in the innards of a subdivision somewhere.
I can see your point. I think times are changing a little bit, and maybe that's something to consider as times change and people know they're going to an open house, would they not map quest it or Google map it and let their GPS take them directly to the spot?
Sometimes they don't know about it until they see the sign.
Sure.
And then they say, oh, I'm going to check that out.
Yeah, it's a good point. Definitely a good point.
But it's prohibited, and it has been since 2014.
At least, yes.
Okay, don't like it, but.
Do you have others? Other tabs you had questions on?
I had a number of things. Flags, most of them.
Sure. Mr. Campbell?
I do have maybe 4 things to talk about. First off, though, to follow up on Alderman Gardner's conversation and Cameron, or Mr. Smith's response. What the area that, or the section, I guess, that you mentioned that covers the real estate signs, shall not be displayed, placed, or mounted in public right of way or on private property without their owner's permission. That's been stricken. So what is the answer to his question, since that's gone now?
It was stricken because it was removed from one section and underlined because it's been added in its own section and removed outside of those.
Oh, so where's that added? I probably missed
Yeah,
that.
so it's added underlined on page 17 under its own section 407.075. And those type of signs are what we refer to as yard signs, not the typical big plywood real estate signs.
But this doesn't mention this doesn't really mention the directional signs that Alderman Gardner is talking about, I don't think. Well, I think we might be missing the directional signs. I have to agree.
Well, I think they would fall under that, again, that poke in the ground sign, as long as they're not on right of way. We're not restricting the content of what those are. And it could say free monkeys. So like I said, we can put whatever on that sign.
So are you
Like a free monkey?
So are you saying, are you saying that poke in the ground sign is identified as a yard sign?
Yard
and that's
sign,
why it
that's
falls under
correct.
this?
Yep.
Okay. Okay, I can understand that. I do happen to agree with Alderman Gardner on this, but that doesn't matter. That when it comes to the votes, when that'll count for amendment or whatever. So going on to page 10. I don't know what to relate this to other than the flag of a whatever. What about flags in people's front yard, on their beside their garage door, on the front of their house? You know, the flag that sticks out on an angle, and you probably know what I'm talking about.
No, you're talking about?
Okay, that have vulgar language on them. That bothers a lot of people. Is there anything in here to address that, or can there be?
Ms. Callaway?
This was discussed at the non-legislative work session specifically, but there is case law related to the regulation of free speech and the ability for a government to place laws and restrictions on that. This ordinance specifically on page 6 in the definition of sign exempts, and this is existing language, in the last sentence in the definition, it exempts non-commercial flags or any flags displayed from flagpoles or staffs, and that they will not be considered signs. That is consistent with Supreme Court case law and the regulation, regardless of what language is on the flag and whether it may be offensive to a passerby or precious to the person that is displaying it.
So we don't have a leg to stand on, do we? Is that, okay. Okay, on page 13. I know that we've got some people in the audience here, but I guess they'll be called upon later, correct?
Absolutely.
I just want to draw attention to the off-premise directional sign, number 4 on page 13. And I'm not going to say much about it right now, but I think I mistakenly told one of the ladies that it was the one on page 8, that it was the one on page 4 that applied to them. But I was wrong, because I didn't realize that was only monument signs. The last one I've got is on page 20. I think I already know the answer to that one. I think I've already gotten the answer to that one. I think that's all I've got.
All right, no other questions? Yes, ma'am.
Somewhere in here, it says, am I right in understanding that if signs were put up before this, that we are not going to make them change them unless the sign becomes old or needs to be changed, and then they have to conform to whatever.
Yeah. That,
the new
yeah,
signs.
that language is part of the existing ordinance, and we're not proposing any changes. Basically, what we call those illegal non-conforming. They can reface those, change out as long as they don't change the overall size of the sign, or if it's structurally failing, then they cannot. They've got to remove those and build a new conforming sign. But yes, we're not proposing any changes to that in this ordinance provision.
And then to the situation of the real estate signs, are we going to put effort into doing something about those?
I know we have in the past, and it has kind of been hit and miss, and definitely we'll keep it on the radar as we got one code enforcement officer that's driving around the city daily and proactively trying to address as much as he can. I will say this time of year, though, he will be busy with grass and dilapidated vehicles.
Busy with what?
Dilapidated vehicles or non-legal licensed vehicles. But yes, he is, I think in the last couple of weeks, he's probably pulled about 5-6 signs. Those are usually the smaller ones. The ones that have been legal non-conform or illegal signs, he sent letters to them to get them to remove them because they're either posts set in the ground in concrete or they're just so large that he can't remove those. And basically the way it's addressed in the ordinance is it'll come back to the city and that owner can reach out to the city to get their signs back.
And what about the political signs?
We do if they're within the city. A lot of them that you will see though are in county. And so we can't restrict those. There's several along NN. Those are actually in the county, not in the city. Across from Walmart on the north side, that's in the county, not in the city. So we can't do anything about those unless they're in right away, then we can go pull those. And if you notice, they've gotten creative and putting those on the other side of the fence or attached to the fence, and they're in the county.
But if it's in the city.
If it's in the city, we will, yes.
Okay, thank you.
And if, by all means, if there's one out there you see, let us know.
Mr. Gardner?
I think that covered it. Mike.
Yeah. Yeah.
Well, I think there was a little bit of, there was some excessive signage during the April election cycle of some August primary candidates that have put signs up before the April election, even though it wasn't their election. They were trying to gain some traction by being up before the election, even though it wasn't technically their election yet, but they've since been instructed or informed, I guess, I'll use the word informed, that they were put up illegally and they pulled them all down with all the plans in the world to put them right back up as soon as the clock hits midnight in 60 days. So, yeah, but it is a bit much. Any other questions from the board? Well, this is always a contentious topic, and this is after two terms as a mayor and 2 terms as an alderman. I can't tell you how many times we've revised the sign ordinance. So it's always a fun one. But anyway, is there anyone in the audience that would like to speak on signs this evening?
I just have one request. It's on page 18, number 3. Signs placed on properties actively for sale or lease. I don't think you need to add properties listing in a listing service because there could be a for sale by owner individual that doesn't have them listed. So that's just added wording for a temporary sign.
Okay. take that under advisement. Yeah,
And then the other question on political signs,
yes, ma'am.
if somebody puts it up 60 days prior to the primary, do they have to go pull all of them before the election in November? Because that's going to be more than 60 days. That's not quite fair.
I think that's what has been done in the past, but Mr. Childers.
Yeah, I think that's the same thing. As Mr. Smith said, I think when you drive around Ozark, it's kind of hard to tell the difference between a city and the county. It's very spotty. So yeah, our rule is that if it's in the right of way and not on public not on private property, then we would pull those. Now, I would, just for clarifying, if it's still in advance of the 60 days and it is on private property, then we would most likely notify the private property owner or the sign owner. If it was on private property, we wouldn't access the private property. I just wanted to point that out. So, but if it's in the public right of way and it is in advance of the 60, then yes, we would. As you said, been here a while now, and most anybody that's running for any office kind of becomes familiar with what's in the city and what's not in the city, but what's a good spot for a sign. So they've gotten very smart, and you know, they pick the best locations. It kind of who gets there first sort of wins the spot. So, but we work within those parameters.
And just as a side note, most of our county elected officials, they're done in the primary.
Yeah,
So we hardly ever have a contested election in Christian County for the general election, but it's kind of the way it's been traditionally. Anyway, any other additional comments? Yes, ma'am. If you just give your name and address to the clerk, please.
Pam Workman, the Baptist Home, Ozark, 1625 West Garden Road, Ozark, Missouri. I just thank you for the opportunity to talk tonight. Okay, so my understanding is to have a directional sign, because as you know, there's only one entrance to the Baptist Home. And you can't see it from the road. So in order to have this sign, we have to have the permission of the landowner. Is that correct? What if they don't give it to us? We have no options. I mean, and especially since we're getting ready to start a massive construction back there. I mean, we're getting ready to build a 224 unit cottages back there for assisted living. And I know that people don't want those big trucks missing our drive and having to turn around in their drive. You know, it just causes congestion. It creates problem with, you know, individual private homeowners. So you're saying that without the property owner's permission, there is no way that we can put a sign anywhere?
I believe that, would you like to speak on this? I believe that's the way the code is written, because there's no position in the right of way that we could put a sign or have a sign installed. Is that correct?
That is correct. I mean, we want to make sure the owner is consenting to allow them to put the sign up there, because we can't legally permit something on somebody's property if they're not applying for it. In addition, yes, as with all signs, they're not allowed in the right of way. In a lot of cases, those become a liability on the city if someone hits that sign. It's a illegal sign placed without a permit. Then yeah, we don't want those signs on the right of way. And a lot of those signs do become substantial in form. It's not, again, just a poke in the ground. They could have a post set in concrete that would be destructive to property or someone. So, yeah.
Yes, if you don't mind. Have you spoken with the property owners?
I have, and I just haven't got a response back from them.
Okay.
I did call them today, and the lady I talked to, it's the people who own Ozark Discount Freight here in Ozark. They're the ones that own that corner lot there. Actually, when my maintenance guys were putting up the sign, the gentleman came over, Todd White came over and said, well, what happened to your old sign? And my maintenance guy said, well, it blew down, and come to find out it was just corrugated plastic. So all we were doing was replacing it, trying to make it look nicer than on 3 green fence posts that it was stuck in the ground. I've been there 4 years. That other sign had been there the entire time, and nobody had ever said anything until it blew down, and I tried to replace it with a nicer sign in the exact same spot, the exact same size. And then I got a letter stating
It's got to come down. And I get it. I mean, I work in healthcare. We have rules, regs that we have to follow as well. So I completely get it. Apologize that I didn't call to ask anyone. I was just replacing an existing sign. So, but I have reached out. I just didn't understand that the sign had been there for 4 years. And then all of a sudden, when I try to replace it with a newer, nicer, prettier sign, I was asked to take it down. So, but I do understand, and I just appreciate you guys listening to me tonight. So thank you.
Absolutely. Cameron, did you have anything else with regards to the sign? I don't think so. The rest of the board? Oh, I'm sorry. I need a control panel up here where lights all come on. Go ahead, Mr. Campbell.
In regards to the Baptist home sign, directional signs to permanent structures like that and permanent businesses, if you want to call them that, are not needed as much now as they were before because of GPS. I mean, everybody's got GPS, and if they type in the Baptist home or the Baptist home's address, unless the information is just wrong, they should not have a problem finding it. And the only other thing I would say kind of piggybacks on what the mayor was saying on whether you'd spoken to the owners of the land there. I mean, you may want to lease it from them for $1 a year, or whatever y'all worked out, or purchase the corner from them, or what, you know.
So if he gives me permission and says, yes, you can sign back up, I call the city, I get a permit, and I can sign back. Is that how that works?
I would rather let the city attorney or the director
Mr. Smith, if you don't mind.
answer that for you.
Yes, the situation would be if this ordinance is adopted as it's proposed this evening, and it is allowed, yes, they can make application for a sign permit, and as long as it conforms to the proposed information regarding size and material, we can definitely permit that, along with getting that letter from the property owner that they're fine with this happening.
So there has to be written permission.
There would have to be written permission, yes.
We just need some documentation basically to put in the file that that they
Showing
are.
that you have rights and access to that property, which hopefully that's something that can be accommodated, because I could see where your point is. You would like to have a signage out there. But then, making sure that the city is covered, it's not in the right of way, it's not blocking access to visual, being on a busy roadway and so forth. So hopefully maybe you can gain permission from one of those property owners. Perfect. Oh, you guys go back and forth.
Is there a charge for the permit for signs?
Yes, there will be a charge after the ordinance is put in place, and we treat it as like a freestanding sign. There's a charge for that permit, for the application and the review of that application.
You know what that is?
For the permit.
Off the top of my head, I'm not sure what that fee is. We'd have to refer to the fee study and see what that fee is. Yes.
All right. Anybody else in the audience tonight? One more chance at comments from the board? Hearing none, this will be held over till the next legislative session. Mr. Flores.
Place bill 3357 on its first reading by title only.
Motion was made by Alderman Flores, seconded by Alderman Campbell to place bill number 3357 on its first reading by title and description only. All those in favor?
An ordinance amending the municipal code of the city of Ozark, Missouri, section 405-350 C4 design guidelines related to signs.
Come on up. I don't know why you didn't just go ahead and bring your nameplate off your desk to put on the podium tonight.
Yeah. If you recall, at one of the last non-legislative meetings, it was asked of staff to evaluate the C4 design or sign ordinance requirements for the downtown along with the historic district. So staff went through that ordinance and are proposing some changes to basically bring it into conformance with the Reed situation. And then also that we found some redundancies from the regular sign ordinance. We found several things that was basically repetitive. So if you start on page, says page 4, under item 7, sign guidelines, we removed that item A as it's already covered in the sign ordinance. On number 8, similar situation. It's already covered under the sign ordinance that we previously discussed. Moving forward on page 5, the flyers, streamers, and banners, grand openings and such, again, that is covered in the sign ordinance, along with item J. And then on the last item there that we're proposing to be G, we're just updating that reference now that there's no longer a commission and just referring to the historic district. Moving forward on page 6, temporary signs, again, removing that section and just referring to the sign ordinance. And with that, that's all the proposed changes that staff has.
All right. Board comments? Mr. Galloway.
Yeah, I wonder, talking to fellow board members, if there might not be merit in postponing a vote on a first reading. And here's why. I think that these changes I don't think I have any issues with these changes, but I would say the feedback that I received from other people on the square is that our window signs, canopy signs are too restrictive, especially for storefront. And I'd like to have an opportunity to talk that over in a non-legislative session to see if there can be a consensus to increase the percentage. So for example, on a canopy, canopy sign shall cover no more than 65% of the side and no more than 40% of the front. Now, if you think about what a canopy sign is, it's, I think that refers to an awning in the front of your building. Now, if you think about what an awning does for you, although awnings aren't always historic, they have an aesthetic of being historic. And it seemed to me that allowing a business to more broadly display their business name on the front side of the awning, more than 40%, would be useful and could promote at least name recognition for the business there. And I don't think it would detract from the historic aesthetic of the square. I don't think that people would look at a front canopy and see what's the Iguana Roja on 80% of it and come away thinking that's garish. And then on storefront windows, at this time, it's restricted to 25% of the total space of the storefront window. If you think about it, that is not very much. And if you think that, you might also put your hours down of operation, that's taking up quite a bit of your window space. And these storefronts, and I know the argument against enlarging the space on storefront signs, but these storefronts were fully used by the stores to advertise their wares historically. And in fact, you can go and look at photographs of old buildings and businesses, and they actually affixed paper on their storefronts to advertise sales and so on. It looks terrible. I wouldn't suggest that, but if you want to be historic, we could bring that back. Or if you want a historic ethic for the square, I feel that, greater care could be put in terms of what kind of style of sign could be there if we want to have that discussion. But I still don't see, I mean, if we have to have a regulation, but I just, historic square, a building that is advertising its business, I just don't see how that tracks from the square, and I don't think that 25% is large enough for people to see from the street. They're driving by and so on. And that, the awning doesn't personally affect my business. I've just heard it from other business owners when they put up awnings. I can say, you know, by way of full disclosure, the size of the storefront would affect me, but it's not just me that I'm talking about. I mean, we have businesses that need to draw in customers, and you draw in customers by having your sign seen constantly, and 25% is too small. I think it's good that, unlike many historic districts, we allow electric signs if they're small, I think about 32 inches. And if you think what those do, those are open for business signs, basically. We do allow that, but I'm not sure that that should count against the amount of square feet that you can have the rest of your signs, which is the way it's written now. And I know that I'm kind of throwing this on there on you, and I certainly don't mind putting up amendments to this effect. But I also think that it's kind of worthy of some in-depth discussion in a non-legislative session, and that is why I wonder if we would be well served by postponing the vote for a month or so we can discuss it at non-legislative more in depth than maybe it's been done before.
Yes, ma'am.
Sorry. Go ahead.
Hey, staff, ask a point of clarification. Was the postponement intended for the bill related to C4 designs and the historic district signs, or just the historic district signs?
The historic district signs.
Okay. Which bill are we on presently?
3.3.
We're on C4 design guidelines.
I'm sorry. I apologize. I skipped ahead. Thought we were at 3.358. So I'll make that motion, and I'll just repeat my entire argument. Next.
I'm gonna bet we can remember it. Mr. Campbell?
I was just going to get some clarification because I didn't know where he was coming from.
Yeah.
So that's all.
I didn't want to interrupt him. He was on a roll. All right, let's get back to C4 though. Questions? Anybody have questions, C4? Anybody in the audience here to speak on C4? Design guidelines for signs? Hearing none. All right, let's hold this one over till the next legislative session. All right, Mr. Flores.
I move that it place bill 3358 on its first reading by title only.
Motion was made by Alderman Flores, second by Alderman Campbell, place bill number 3358 on its first reading by title and description only. All those in favor?
An ordinance amending the municipal code of the city of Ozark, Missouri, section 405, 478, historic overlay district signs.
All right. Let you go ahead and start before Mr. Galloway starts his.
The proposed ordinance in front of you and the existing ordinance, the most of that language is a carryover from when we had a previous commission. But just to go through the revisions staff is proposing, and we're anxious to get more feedback on some of the future revisions. On page 1, there was an item number 3. We're just stricken that as we didn't feel it was necessary to have in the ordinance. Thought it was covered with the existing sign ordinance. On page 2, item number 4, same scenario. We think the existing sign ordinance covers that item. Further down the page on on item number 2 and then 3. Item number 2, staff has felt like that was not required because that is the existing situation of any sign that we request. Depending on the size and the substantial structure of that sign, it has to be a professional fabrication, professional design. And then the last time, item number 3, we're removing that restriction as in some cases it is too stringent. It doesn't offer flexibility. And in some cases, a business has a specific shape and sign of their logo and size or sign. Moving on to page 3 at the top of the page. Actually, I think that's a carryover. Yes, that's a carryover from the prior page. On to page 4, under window sign, staff felt like we see a benefit or a nice feature where it could extend from one window to the next to carry out the theme of their advertisement. So we're removing that language under item number 2. Moving forward to page 5, under display boards, staff felt that was already covered in our sign ordinance and didn't need the information in this ordinance. At the end of the page is just a typo staff is correcting. Moving on to page 6, A-frame signs. Again, we're just letting those signs be covered in the sign ordinance. Same with the grand opening signs at the bottom of that page. And then the remaining on the following page, page 7, the sign ordinance will address those as well. So with that, be happy to answer any questions.
Your Honor, I move to postpone the vote on first reading for 335A following for the first meeting following for the first meeting in August.
First meeting in August. There's a motion on the table to table this bill until the first legislative meeting in August. Is there a second? Motion was made by Alderman Galloway, seconded by Alderman Alder, to table this bill until the first legislative session in August. All right. Any other discussion, Mr. Campbell? Do you have a question?
Yes.
I don't know if I can ask my question now that there's a motion on the floor. But
Oh, I'm sorry. Yes, I'm confusing 2 different rules of procedure, so I apologize.
okay,
I'm in some organizations where it takes a motion and a second to even get the discussion, so I apologize for that. All right, all those in favor of the motion on the floor to table? Any opposed? Motion carries. Mr. Galloway.
Your Honor, I move that we place bill number 3359 on its first reading by title only.
Second.
Motion was made by Alderman Galloway, seconded by Alderman Flores, place bill number 3359 on its first reading by title and description only. All those in favor?
An ordinance authorizing the city to enter into a regional broadband initiative participation agreement.
All right, Ms. Payne.
Couple weeks ago, maybe a month, time seems to fly by in the summer for me. We did the IGA with the regional group and we went into the agreement. This is basically step 2. We need to create a board that will allow for them to look at the consultants and decide what we're going to do. So this agreement will kind of outline what that looks like, who gets to vote, who's going to be the clerk, and how that agreement will move forward. And then they'll bring, there's no cost to this because it's just basically forming a board with all of the committee members that are working together in that regional board. So it's step 2 from what we did the last time where we just went in a circle for a little while, so.
Mr. Flores.
So did all the different partners come together and agree to move forward with it? Is that why this is coming back around?
We are the last group to sign, so if we do decide to move forward with it, we'll need to expedite it tonight because everyone else has signed this RBI agreement and we are the last group to sign it.
So this is everybody coming together and actually.
This is everyone coming together saying,
everybody's even, this is what the cost will be, and it's broken down in that same agreement that we outlined before. But this basically just says that the Greene County Clerk will take care of clerk duties. It sets up the parameters. That's how the RBI board will function. 7 members, everybody gets 1 vote, and then we'll look at the consultant as they come forward. And so it just kind of takes us to that next step where we can start trying to pick a consultant to get the agreement to move forward.
Thank you.
Any additional comments, Mr. Campbell?
Can one of the aldermen be on that board? Or is that board already established, or what is?
It's not established. When I was reading it, it just says that we have to appropriate some person plus another person as a backup, I think is what the stipulation said. Is that correct, Amanda?
The reason I asked my question is, I'm not sure how much, I don't want to say control. I'm not sure how big a part the city plays in answering contingencies questions on this piling of dirt in people's front yards, which is on a utility easement. I've got a lot of people from 1, 2, 3, at least 4 of our bigger subdivisions up north that really have an issue with what they're being told has been done and what has actually been done. And I just feel like if we did have somebody like myself, an alderman on the board, that maybe we could have a bigger say in this, and maybe we have a bigger say than I've been led to believe. I don't know, but I've not been able to get much accomplished on helping these people that have real nice yards. Everybody that has complained to me has real nice yards, and we're just not getting good answers. The reps of the broadband companies is telling us they're doing things, and then they're coming back and apologizing and just shuffling it down the road, saying, "Oh, we're sorry. My salesmen were supposed to do this, but they didn't." And then the next 2 complaints I get, I ask them specifically if they had door hangers or something telling them that, hey, we're going to start digging your front yard. And they said, no, we saw them, the locate guy sticking flags in their yard, and a few days later they were digging up her yard, and 2 weeks later there's the dirt pile still there killing grass. So my question is, do we have any say in it? If not, I'll just have to tell my contingency I don't have any say in it. I mean, obviously I don't have any authority.
Yeah.
But I do want to represent them.
Sure.
To my, as much as I can.
It's been a difficult situation up there, Mr. Childers.
I just wanted to make sure everybody on the social media knew, really don't have anything to say about your request. If certainly if the board wants to be, a member of the Board of Aldermen would like to be on the RBI board, that's certainly okay. That's your decision to make. I just wanted to make sure that anybody in the audience or anybody to listen knew that this particular agreement is just to create a board to go through the consultant selection process for doing a study. There's no broadband that's going to be implemented. There's no broadband that has been decided upon. There's no decision that has been made to deploy broadband in any of the cities that are cooperating in this. This is just a group of communities coming together to see what it would cost to evaluate
What it would cost.
the cost of possibly deploying broadband in a regional basis. And I highlighted this part right here because I think it's important to note that in section 6.2, there is a termination agreement. And we certainly worked on this. And I think all of us as members were like, what if the study comes back at a price that somebody has to say, we just really can't do that? Then we wanted to make sure we had an opportunity to be able to bail out. let's say the study itself is just too expensive. And we don't anticipate that's gonna happen, but again, I didn't want anybody, new alderman on the board too, hadn't been real familiar with this. I didn't want anybody to think we were building broadband, because we're not. This is just to go through the process to select a consultant, put it out for bid, find out if we actually want to do the study. So, but again, if somebody wants to be on that board, I am all for it. I just wanted to make sure everybody knew that. So
I probably misinterpreted the intent of this. So I don't think this would be a board I would
So you,
serve well on.
you're gonna withdraw your.
I'm going to withdraw
recommendation
my, yeah,
To put yourself on that board.
but I do appreciate the clarification.
now, if this goes forward, and you decide to do it, then there could be a committee or a board or something that you may want to have an elected board of aldermen on. That's if we go as far as to select a company to actually install broadband. We're way far away from that at this point. So I just, again, wanted to bring that up.
And as of now, the intent is for who to sit on this committee?
Right now, Ms. Payne.
Ms. Payne.
is the project,
I don't know. Well, thank you.
yeah, project. Well.
Unless Mr. Campbell wants to. I mean, I was ready to let you do it.
Maybe Mr. Campbell can be the alternate. to
There you
do,
go. I get sick a lot, so, no, I'm just teasing. I'm just teasing.
All right. Are there any additional questions for Ms. Payne with regards to this contract?
And like I said, expedite if possible, because they're waiting on us. Sorry.
Is there anyone in the audience that would like to speak on this evening? Hearing none. Anything else from the board? Mr. Galloway?
Your Honor, I move that we place bill number 3359 on its second reading by title only.
Motion was made by Alderman Galloway, seconded by Alderman Flores to place bill number 3359 on its second reading by title and description only. All those in favor?
An ordinance authorizing the city to enter into a regional broadband initiative participation agreement.
Any additional comments, questions, concerns from the board? Hearing none. 020.
Your Honor, I move that we enact bill number 3359 as ordinance number 22-020.
Second.
Motion was made by Alderman Galloway, seconded by Alderman Flores to enact bill number 3359 as ordinance number 22-020. May I get a roll call vote, please?
Alderman Elder. Aye. Alderman Snyder.
Aye.
Alderman Galloway.
Aye.
Alderman Campbell.
Aye.
Alderman Gardner.
Aye.
Alderman Flores.
Aye.
You have 6 aye votes, motion carries.
All right. And back to Mr. Galloway.
Your Honor, I move that we place bill number 3360 on its first reading by title only.
Motion was made by Alderman Galloway, seconded by Alderman Flores to place bill number 3360 on its first reading by title and description only. All those in favor?
An ordinance amending the municipal code of the city of Ozark, Missouri, section 14030, general guidelines regarding sale of surplus goods and real property.
Okay. I guess I can explain this one. So this bill was kind of came to me out of a little bit of a necessity to go a little bit above and beyond where our current code was for surplus property and be a little bit more transparent in the way in which we handle transactions with regards to surplus property. So all my notes were passed along to the city administrator. We drafted the document, and I can't read it up there, but I can give a synopsis of it, I guess.
Well, I want to get the right section. This is our procurement.
Yeah.
Section A. Section A.
Okay.
All right. So we start off with the declaration of surplus goods and real property. So the city administrator would be, as far as real property goes, the city administrator would deem that a piece of property be surplus. Then the Board of Aldermen would agree to that, and then the process would start from there. So, do you have it here? So then what would be new here would be, instead of just identifying a property owner or a person in our community that would like to buy a property, we would actually enact a complete process in which I'm not in the right section, Mr. Flores. I apologize for not being prepared. I'm gonna go back up there and read it from up there if I can. It might. I'm having a problem going between two different sets of, okay. All real property that's unneeded by will be declared surplus by the city administrator with approval of the Board of Aldermen and be sold at a public sale. The public sale would be held at City Hall by the mayor or a designee. The property would start at the appraised value plus any cost associated. So closing costs, the appraisal cost, that would all base for the initial sale price. And we would take bids in $500 increments. The property must be posted for no less than 3 weeks, must run in the local newspaper for no less than 1 week. And we will create a tab on the city website for surplus property. And anything real property will be posted on there. We'll have all that notification process, as well as goods, any surplus goods we have. We've been using for quite a few years Gov Deals. We will also list any surplus goods that we are selling, whether it be police cars or staplers, desks, anything that we sell, and we'll reference the Gov Deal site so that people will know what we have. So anybody that's interested in any kind of surplus property, if they're checking the website every couple of weeks, they will be able to see any properties that we have and we are selling. This would take out any of this. You have to be in the right place at the right time to know if something's being sold. We'll be having the information out there in front of everybody at all times. So yeah, there it is. The public sale shall be conducted at City Hall unless otherwise designated by notice and should be conducted by the mayor or his or her designee. It only says his in there. I guess maybe because it happened to be me at this time. But the bidding shall start at the base price bid and increase by $500 increments until the bidding stops. Once the final bid is secured, the purchaser will have 30 days to close on the property. So I think what we've got here is a new policy that will serve us well. It should take out any accusations that we're a good old boys club or you have to be in the right place at the right time or know the right person to be able to buy these properties. And that's my goal. Transparency has been my goal ever since I started serving in public office. And I think this just takes what we were doing, which was completely compliant with state law, but takes it to the next step and makes it crystal clear. And anyway, that's the process that I've outlined in this ordinance, and I'll take any questions. Mr. Gardner.
I like the sounds of this. Assuming that it does pass, at what point will we review the property that we do have to determine, particularly the parking lot, to determine whether or not it is surplus?
Well, I would defer back to the city administrator to make sure that is a surplus piece of property.
I understand that
as following this policy, it would be declared surplus.
Around a lot.
It would be declared surplus. Once it's approved by the Board of Aldermen, then immediately we could start following this process. Now, this process would, unless the board would like to expedite this, which I don't know that there's a necessity to. I don't see it as a necessity to expedite it, but it would follow once it's signed into law by me, which is typically the day after an alderman legislative session. I will sign whatever bills come forward or whatever ordinances. I typically sign them into law the next morning. Mr. Campbell?
A couple of things. I'm wondering if if we should require the successful bidder to give us a copy of of a bank letter or pay 10% cashier's check on at the end of the sale? Or what happens if somebody backs out after we have the auction?
That's a great question.
There'd be something there that would tie,
Well,
obligate them.
my original language is that they would have to be able to pay immediately, but not everybody's quite ready for that. You know, they may need to go and finance that. I don't think any of our properties are going to be, at least none that I see in the immediate future, are a huge investment monetarily that they wouldn't be able to secure some kind of financing.
There are a couple that probably would be difficult to buy. I'm not saying they would be. Maybe somebody can write a check for the whole thing. But they could range anywhere from, $5 to $105,000. It just depends. And it also depends on which properties we're talking about. That being said, it is a typical process. Now, I don't know in the public sector, but I know if you were to go and buy a foreclosed piece of property, if you were buying something even from the Missouri Department of Transportation, which I've personally experienced before, there is an amount of down payment that is typically required. It could be 10%, it could be 20%, but I've seen that as a very common practice, to be able to say, okay, you got 30 days to close, because you got to give yourself and the title company and everybody time to get that done, so that's not a unrealistic request, I don't think, to require some form of down payment to hold an escrow until such day that closing is complete. So it's not a bad decision.
And I'm open to any amendments that you may put forward on this.
Well, I'd like to get the rest of the board's pulse before I go into amending it, if I could.
Mr. Gardner, I believe, is next.
That's a good idea. I think there should be at least a 10% deposit given at the day of sale and held until closing. And but then if that happens, then you have to decide what to do with the deposit if they don't close, which is another whole issue. But at least they're serious if they put it down. Mm-hmm. You could put in there it would be forfeited in the event the contract doesn't close. If you did that, you might want to go with 5%, but you might want to go with 20. I don't know, but just things to think about. But money down is a good idea.
Okay. Mr. Galloway?
Actually, Mike, as far as the process itself, it makes sense. The city administrator would have discretion to identify surplus property. The board would have to agree with that assessment. I have a question about surplus property. It would seem to me that would not apply to this scenario, and I'm throwing it out there for the mayor to respond. We grow out of this city hall. Developer comes to us and says, we'll do a land swap, put some other things together, and you can have your city hall there. We build. It would seem to me that under this ordinance, we would be able to make that deal, even though it's not bid, because this would not be surplus property. Would that be your take on the situation?
I don't know that I would agree with that necessarily. To me, surplus property is anything that we're no longer going to be using, and we're going to dispose of it.
Well, it's just that, and I'm not arguing how you want it to be, but I think the ordinance says if it's unneeded, if the city administrator says it's unneeded. I mean, I think it's a fair question to ask. Can the city still enter deals as to property that is useful to the city without going through the bid process? And then I guess my comment would be, does that tie us down to where we don't get the best deal for the city in the scenario like I was talking about, if we don't restrict it to surplus, strictly unneeded property? Throwing it out there.
Yeah. I think it's a good question. I don't know if Ms. Calloway has an opinion with regards to a land swap. Would that be a violation of the ordinance as written? Because it hasn't gone to a surplus designation yet?
Technically, the ordinance as drafted would only apply to that property that has been designated by the board as surplus, which would be unneeded. So that would be a way to switch ownership of the property without following this process. But there are similar processes where a trade of property is anticipated. In your LCRA law, it does identify that the LCRA itself can trade property with the municipality. So it is contemplated in other sections of law that municipalities with other political subdivisions may be allowed to trade property, real property that is. So it isn't unheard of, and this ordinance would not apply to that under that scenario.
And just remind me, because we had a conversation, when we're going back to surplus goods, we still reserve the right to transfer ownership of police cars or public works trucks to other municipalities. We did leave that in here. Correct?
Yes, in relation to surplus goods, not real property, all that was amended on that was that the department director can bring it to the attention of the city administrator that they have surplus goods. And then the advertisement of the surplus goods will be made on the city website, including that link to whatever location we decide to sell it. But the city administrator at any time can dispose of surplus goods, not real property, with a trade to another municipality or a state government agency.
That's how I remembered it, but I want to make sure. Yes, ma'am.
Do we have to say surplus property? Can't you just say city property in there? You take that definition out. Why do you have to say surplus?
Because it's something we no longer need,
Yeah.
which
I didn't know.
I guess just with every other organization that I've seen, the Ozark School District does the same thing with surplus goods. That's how it's listed as surplus goods. I believe that's what it says on the Gov Deal site. It refers to the unneeded items as surplus.
I didn't know if you have to have the formal, somebody saying this is surplus and somebody agreeing to it. Or if you don't put that in, you just agree as a board that you can sell it. I don't know. Surplus make it better?
I think so.
Okay.
To me, it does anyway.
Okay,
The way I think of it.
okay.
Mr. Gardner?
This may never happen, but most of the time it's going to be surplus. But what if we had something that we were using and that we had every intention of continuing to use, and somebody came and made us an offer? How would we handle that?
I think that would be something that's, I think that's kind of where we've gotten into what I see as a necessity for this. We a couple of years ago, a building was sold that we weren't looking to sell it. A certain party came forward wanting to buy it, and it was sold and nobody knew about it. And I heard about it from a lot of people in the community. And that's where when I said a minute ago, you have to be in the right place at the right time or know the right person. I want to alleviate all of that. I want to alleviate that speculation that people may have that we're not above board, because I think we are above board. And I want to make sure that anyone that's listening or anybody that's watching this knows that the city of Ozark followed the ordinances as written to the T. So nothing was done wrong. It just wasn't quite as transparent as I would like things to be.
Well, to your point, and to Heather's, maybe it's a good thing to not use the word surplus, because at the time that was not surplus. And so if that same sort of a situation could come up again, we would handle it differently, but it's not surplus. And that may be just
I think at any given time, if we can use that building, for instance.
Yeah.
Somebody wants to buy it, city administrator says, yeah, I guess we don't really need it. He can recommend it to be a surplus property.
okay. All right, that's good.
And once the board agrees to it, then we would go through the process. We wouldn't be identifying a specific person that could
That
be the
makes
buyer.
sense.
Everybody would have an opportunity to be the buyer. Mr. Childers.
That was me.
Oh, I'm sorry. Oh, I get to look in one direction and that's all I end up seeing.
Anytime
Go ahead,
we
Mr.
change
Campbell.
at the same time.
Well, I'm just gonna say one thing, because you've actually touched on one of them, and you totally covered one of them. I don't think we want anybody to be able to perceive that we're just out here selling stuff. I think it's got to be deemed surplus property. So really, I guess the mayor kind of handled both items I had, so I'm good.
Okay. Now, Mr. Childers.
I think with any situation that you have circumstances that you have to take into account. This is really the main goal of this was to once surplus property or what something the city owns is deemed to be surplus, there is a very transparent process in place that we follow to allow for everyone to know. Then you may have a different situation where the city may own something. It's never been declared necessarily as surplus, but we are approached with a set of circumstances that I may have to take back to the board and say, there's a set of circumstances somebody has presented to me, and I believe I need to present it to you. In the case of the property that I think we're referring to, we bought that on a temporary basis. We knew we probably weren't going to stay there. We were recommended by the police department certification that we probably wasn't a real good long-term solution for our evidence room. And by being able to dispose of that property, we were able to receive all the funds back that the city had put into that property and then some to be able to go build the permanent facility that we needed. So in that circumstance, we were approached with an opportunity. The board said, that's a good opportunity for the community. We need to take that. And then it really became surplus property. So I see what you're saying. And however the board wants to do that, it's fine. I think probably what I would work with Ms. Callaway on is certainly so that I can remain consistent in my evaluation is I'll use the variance board or the Board of Appeals as an example. The Board of Appeals is a board that exists because they are needing to make a decision about a situation where there's a difference of opinion. And they use a tool called findings of fact. And they actually have a list of, I don't remember, 7 or 9 things. It's different for every community. But they say, okay, before we make this decision, in this case, before I would declare something unusable, no value, or surplus property, I would probably want to develop a few findings of facts that I always looked at to say, you know what, I went through the same test on this to determine this is of no use to the city, no, you know, or something that we wouldn't get benefit from. So I think that would protect me or anybody else in this position to say, you know, if I'm going to make this determination, I need to remain consistent. I need to go by the same set of rules as I do on everything that I evaluate. But I think that would be important. So I think I might work with Ms. Callaway on that and develop that so that way, when I do bring something to you, you know, I didn't consider these 3 factors on one piece of property and these 11 factors on another piece of property, because that would be like apples and oranges. I don't think that's the right way. And I think that's contradictory to what you're trying to achieve with more transparency. We need to be consistent within our transparency as well. So I just wanted to bring that up. I think you do definitely have different circumstances. Sometimes it may be surplus property, and we've gone through the steps to determine that. As we develop those steps, we'll do that. Or you may have something that somebody that presents an opportunity to the city, and as an elected body, you have to evaluate based on its merit and determine whether it's a good deal for the community or not. You know, so that's all I wanted to say, Mr. Mayor.
Thank you. Mr. Gardner, did you have something else?
Oh, no.
Any other questions or comments from the board? Anyone in the audience here to speak on this bill this evening? Mr. Campbell, did you want to make an amendment?
I'd like to move that we amend this bill to include a 5% day of sale of bank letter, cashier's check. Could I defer to the city attorney to word this? Yeah, escrow, it
Escrow.
would be good, yeah.
5% of the total purchase price to go into escrow until closing? Are you
And that would be on the day of the sale.
on the day of the sale? Are you suggesting language that references Mr. Gardner's concerns with regards to forfeiture of the escrow fund should the closing not happen, or do you want to
Yes.
mess with that, or?
No, I think we need to have some teeth in it. I think if what do we give them, 30 days to pay for it? Is it a certain?
Well, I think one of the comments that was made, what if the closing wouldn't happen within the 30-day
Okay.
timeframe?
We presently have 30 days closing in the ordinance.
Okay.
It could be suggested that the 5% escrow would be retained by the city to cover only those costs that the city had expended, such as the appraisal, the cost of the auction, that's already included in the base price. And then the rest would be obviously turned back over to the purchaser.
Okay.
All right,
I'm good.
all right. You want to read back what his amendment's gonna be? Because we're gonna make an amendment here and a vote on it, so I want everybody to know exactly what it is. All right,
A motion made by Alderman Campbell to include 5% of the total sale price due the day of the sale to be held in escrow until the closing to cover
And
the city
I'm trying to think about
expenses.
how to word it. And should the,
City's
should the
expenses.
closing fall through?
in cover city's costs.
Okay.
Yeah.
Sorry, I'm still writing notes here.
So the motion doesn't need to cover what the 5%,
And they said in the event that this sale,
if it falls through the city.
Fails
keeps
to
the money.
close.
no, the 5% of the costs that cover the costs expended by the city.
Okay.
All right, is everybody clear on the amendment? The motion was made by Alderman Campbell, seconded by Alderman Flores. All those in favor of the amendment? Oh, you had a look of concern on your face. Oh, all right. Did you say yes? Okay, I didn't. All right, perfect. That amendment passes. This bill will come back at the next legislative session in its amended form for its first reading. All right, moving right along. We're out of ordinances into resolutions. Mr. Flores.
Move that we read resolution 1967.
All right, motion was made by Alderman Flores, seconded by Alderman Campbell to read resolution number 1967. All those in favor?
Resolution by the Board of Aldermen of the City of Ozark, Missouri, approving one reappointment to the Planning and Zoning Commission.
All right. We had one gentleman that unfortunately had missed missed 3 meetings and was removed. He is requested to be back on. That also came through the Planning and Zoning Chairman to reappoint him, and that's what I've brought forward to you guys this evening. You might have any questions or comments, concerns about the resolution? Hearing none.
Move to adopt resolution 1967.
Motion was made by Alderman Flores, second by Alderman Campbell to adopt resolution number 1967. All those in favor? That is unanimous. All right, second reading, final passage of bills. Mr. Gardner.
Second final readings.
Motion was made by Alderman Gardner, seconded by Alderman Campbell to place bill number 3352 on its second reading by title only. All those in favor?
An ordinance authorizing the city to enter into and execute an intergovernmental cooperative agreement with the Ozark Special Road District.
All right. Any comments, questions, concerns about the bill? Perfect. Hearing none.
Bill 3352. So it's 021.
Yes, sir.
021.
Motion was made by Alderman Gardner, seconded by Alderman Campbell to adopt bill number 3352 as ordinance number 22-021. May I get a roll call vote, please?
Yes. Alderman Snyder. Alderman Gardner.
Aye.
Alderman Flores.
Aye.
Alderman Galloway. Alderman Campbell.
Aye.
Alderman Alder. We have 6 aye votes. Motion carries.
Report of officers, boards, and committees. Mr. Childers.
Mr. Mayor, I just want to remind everybody that this Thursday, we do have our non-legislative work session. We are doing something kind of unique. The bus that we're taking to take the tour will pull out of here promptly at 8:30. We have to do that, otherwise we won't make it back for the second part of the presentation. I have asked the city clerk to be creative in our breakfast needs, and so you'll have a grab and go kind of breakfast, but it'll be good. I promise you that. So we'll jump on the bus and spend an hour with Cameron as our tour guide. And we're going to look at a lot of things that are going on around town. Then we'll make it back and we'll talk some more about planning and economic development. So. Nah, I don't know. That would take far too long. That's a whole nother trip in and of itself. Yeah.
Is that it for you?
Yes, sir.
Inside your package, you had a written report for the OC, Parks and Recreation by Ms. Payne. Do you have anything to add to it? Anyone have any questions for Ms. Payne with regards to her report? Mr. Campbell?
Update on the inclusive playground, maybe Thursday or the next legislature. It doesn't matter to me.
She's gonna give it to you right now.
Okay. All right. I figured she could.
So the playground equipment is put in, but it rained so much, so we now have to go put the squishy tile in. And I can't do the approaches until the squishy tile is in. So that's coming. It's in process. It's just, we have been telling everyone early summer. So we had no intention of this being done before at least June. So we're still on track. The equipment is in, but like I said, we have to pour and we have to get that ready. So we're just kind of lining up contractors to move forward with that. So.
Okay. Maybe I misunderstood a few months ago. I thought we were looking at April to have that open.
No.
That
We
was
have
not
always
voice-
said,
that was not
we have
voice.
always said early summer.
No. Okay. Okay. Next question.
Yes.
Is our outdoor pool leaking or did we just let water out of it?
We're just gonna figure it out.
Okay.
Well, it's going somewhere.
Yeah.
So we better figure out where it's going. So
Okay.
that's how we spent our day.
Curiosity. Okay.
All right. Planning and Development had a written report. Do you have any questions for Mr. Smith? Come back up. Got a full night at the podium. Finish it off there. Go ahead, Mr. Gardner.
I just want to know what the status of Marabella is, if any.
I think I'll turn that over to Mr. Childers to answer that question.
I can tell you that officially, remember, we had a non-legislative meeting back in March with the developer, the staff, and the Board of Aldermen. It was determined at that time, or directed by the board at that time, for the staff to put together a proposal for the developer, which we did, and that was sent to the developer. We never got a formal response to that proposal. So right now, formally, The developer has been given a proposal from the city regarding infrastructure, which covers water, sewer, and transportation. I know there are some upcoming meetings. I know that I should say, I know that the developer is interested in continuing to have conversations and move forward. And we should know more about maybe what their intentions are this week, and hopefully they'll respond to our proposal. But that's where we're at. So it ball's in their court.
The reason I ask is this has been a very interesting very interesting situation all along. He has been approaching Alderman, wanting to talk, and I don't know what he wants to talk about.
Particularly certain either, like I said, we did what we said we would do and made a proposal. I will give you a little bit more of an update. You may recall that we have been working on a project for some time, which is a transportation study. You know, the way Ozark is laid out, you sort of have the north section, the center section, and the southern section of Ozark. Well, just as we would do a water master plan or a sewer master plan, we're working on transportation master plans too. That being said, we have had our third-party engineers working on collecting the data of each one of those sectors so that when we take that information, we can have a compact and contiguous overall transportation master plan. Part of the proposal that we made was that, listen, we are going through this project right now, and it is collecting a lot of data. So as part of the proposal we made was that we know you're concerned about the potential cost of traffic improvements as a result of the very large development that you're proposing. So what we will do is we will have the engineers. Now the developer had the opportunity to do this themselves. They typically are required to do a transportation impact study. The developer could have done the transportation impact study. He chose not to do that and said, well, maybe that's something that we can work together on. Our proposal was that we will modify our scope of work and we will collect the additional data that would otherwise be needed to be collected by the developer, because we are 90% through this study. So doing an additional amendment, which did cost an additional amount, but it's data that would have been valuable for us anyway, because we therefore could look at the maximum density of how these properties were zoned on the north side of town and say, regardless if it was this developer or another developer, with this density, what would the road improvements need to be? And so that's what we were trying to do from a planning perspective all over the whole community. So we just received that final report back Friday. And so now we do have that information. And so that is information that we are happy to also now turn over to the developer and let him see so that he is aware. And so I think the conversations going forward will probably be more about transportation and who's willing to do what, and we'll have to evaluate, you will have to evaluate all of that.
When will we have that report?
We just got it Friday, so we're gonna have more conversations about it tomorrow. We certainly want to go through it first and make sure we understand it. It's a pretty in-depth report from an engineer about transportation and vehicle trips per day. So we will make sure we understand that. And then certainly we are, it's public information, so we're happy to give that to anybody who wants to see it.
My concern is that he is continuing to want to meet individually with Alderman, which I understand. It's
his prerogative.
Yeah, and I don't want to sound to him like I'm disinterested, because if that thing gets done, I really do. But we're a long ways from there, and he's not exactly, doesn't seem to be exactly eager to move the thing forward. So I don't particularly want to have a meeting if he hasn't received all the information he needs to have to know what we're willing to do.
Certainly. Yeah, and like I said, we're happy to provide that. We're going to talk tomorrow about it, and then we will be able to provide that to him and his engineers. And so that way they can, I would assume that they would get back to us and say, well, this is what we're gonna propose, and we'll have to look at a new proposal maybe from them. Now, I don't know that for sure, but I just assume that's the way it would be. Yeah.
Because I want to meet with them. Not excited about doing it, but just out of courtesy.
You know, last time
Everybody has to say.
we did something that I thought was very beneficial. I mean, we called a special meeting. We do that often. It was a non-legislative meeting to sit down and specifically talk about this development, which is very large and would have a large impact on the community. And so we could certainly do that same format again, because I thought with everybody in the room, developers, board, staff, all the communication that's taken place over the last 2 years, we were able to put that on the screen and everyone was able to see that. So that anytime any topic came up, we were able to put that up there and say, oh, this is what it was from, you know, March of 2020, you know, because we've all slept since then and I can't remember every single piece of paper. We can do that.
We rarely have done that. I mean, that's the first time I ever know that we have done it in the last 6 or 7 years. And now we're talking about maybe doing it twice.
I only suggest that format. Jeremy made an excellent point today when we were talking about the magnitude of this. Because we just briefly looked at the traffic study. I mean, literally briefly. You know, take Chesterfield Village, for example. This is 240 acres. I've been here a long time and I've not seen another development proposed that was 240 acres. That's over 850 new dwelling units and other uses, commercial. So when you look at Chesterfield Village and the density and you realize that's about half the size, this is a pretty significant decision that you're going to have to make, because this is a long-term project and it will impact the city of Ozark for a long time. So I believe that maybe, you know, additional meetings such as this may be warranted, but again, that is completely your decision.
Well, my memory on this new arrangement we have with OSRD, where we can switch some roads. Blue Stand and Farmers Branch, as far as maintenance goes, not snow removal, are those going to remain OSRD?
Those do remain OSRD's roads. They do own those roads and they are responsible for the ownership, maintenance, and snow removal of those roads. Yes.
So to go back and talk a little bit about meeting, Mr. King has asked for yet another meeting with me. The last meeting I had with him was with the OSRD, President Chris Summers and himself and myself. We discussed transportation issues. That was the big kind of holdup, was transportation. After over an hour, I had another obligation and had to leave. I told Mr. King that once you guys work out your transportation issues, because it doesn't really involve the city of Ozark. The improvements to the roadways are not our roads. Those are special road districts. I told him as soon as he's ready, we'll put this back on and we'll start the process with the city of Ozark. I hadn't heard anything until the other day when I got a request for another meeting. So I'm not sure where we're going, but I agreed to the meeting on the 23rd. And I know that he's reached out and talked to multiple aldermen about the topic, but I'm not sure. I still haven't been able to gain, what do you want from us? I want everyone to know that we, the city of Ozark, we are not holding up this process. I'm ready to put it in front of the Board of Aldermen the minute I get clarification that they're ready to move forward. So where the holdup is, I think it is the developer wants a promise that there will be no additional restrictions put on him when he plats phase 2. But that could be 3 to 5 years down the road. And I don't know that anyone can agree to that at this point in time. So I know it would be, I think it would be foolish for the city of Ozark to agree to no additional restrictions when we don't even know what that's going to be in 3 to 5 years.
Well, I want to cooperate because I want to see it happen.
Absolutely. We must protect the city at every opportunity. So, Ms. Alder.
I just wanted to ask you about Billy Gales. What are they doing there?
for quite a while, they've been talking about redoing the entrance and closing a little more area that's outside and expanding the building. So it's just been on our report for quite a few months now. They did do some upgrades in the kitchen, but this is regarding some of the entrance waiting area, if you will, of the building.
Thanks.
Any additional questions for Mr. Smith?
I can add a few more comments or highlights.
Go right ahead.
If you're up on the north side of town, on the eastern end of the building where Primus is at, you'll start seeing the infill improvements for Urban Grounds Coffee. So that should be underway pretty soon. West of Arby's, Whataburger has started the groundwork there, so you'll see the disturbance on that property. Starbucks, we are still waiting for them to pick up their permit, but it's all ready to go, just waiting in their hands to make action there. No, that was a separate demo permit, but their construction permit now is ready. Sonic, we've heard a lot of, I guess, rumors, if you will, about that. It is not a two-story building. There's no 2 floors on it. It's just a tall building. There will not be 2 buildings at the end. The original building will be knocked down. To our knowledge, and we inquired with the contractor early on, there is not a planned playground at that facility. So just to address some of those rumors at this time, that's what we're aware of. And then the latest update from the contractor, they do plan to close in that June, maybe July timeframe and reopen in September, as they're kind of making that transition from the existing building to the new. So that's all I got.
All right. No other reports, so miscellaneous comments and announcements. Members of the Board of Aldermen and the mayor. None? You want to say something? I know you are. Go ahead.
Well, going back to something I brought up earlier. Is there anything that I can tell these people whose yards are being dug and then not fixed back in the time frame they think they should be, I guess you might say? Yeah. I mean, I see the contractor side of it. That's, I did that for years. I know what's happening with the contractor and the second tier contractor and the third tier contractor. And, you don't bring a third tier contractor in to fix all the bad places until you get enough there for him to work on, because it's going to eat his lunch if you bring him in every time you mess up somebody's yard and come back and fix it back.
So are they, I guess for me to fully understand, I don't know what to say. But are you saying that typically in this kind of situation, you have the person that bores, they dig, they put the conduit in, and then you may have somebody else that pulls the fiber, installs the fiber. You got to get through the phases till you ever come back, like you said, and actually repair the situation. Or we run into a situation where they'll put that conduit in and then it may sit there for a week or 2 weeks or 3 weeks, just stick it in the ground. Is that what's happening? And they're just not getting the job closed out?
That ain't what's happening. I mean, it's not that let's say, for instance, Mead Drive, that north-south drive up through there. They started it several weeks ago. And I think with a little bit of publicity that it's gained, they are kind of doing better than they were before. Mm-hmm. But there's still places in all 4 of these subdivisions where when they dig the dirt, some of the dirt they're putting on the sidewalk, which I'm not sure if we like that or not, but whenever they dig the hole, they're stacking it on a beautiful lawn. Mm-hmm. They're not doing anything with it for weeks. And it just stays that way. And all the calls I get are they going to fix it back like it was before they dug the hole? Mm-hmm. And they are, as far as I know, they're keeping within their utility easement. I've not had anybody say, well, they're coming way over here on me. So they are within their utility easement. And, I just don't really know what to say to people. I don't think we're going to be able to say anything that's going to keep them happy. Now, we do know that companies that's in charge of putting the fiber in, has made a comment to several of us via email that that before they started anything in that subdivision, they had people go around and hang door sign, on door knobs, stuff like that. Well, we found out later that that was not true. That actually happened was somebody in that company told somebody else in that company to do it, and they didn't do it. That's the story I've got to, and I don't know if you've heard all that or not.
I've heard bits and pieces, but I knew there were a lot of people involved in the conversation. I guess I'd like to follow up on this topic with you so that I can better understand, and if we could look at each one of the properties that have been disturbed individually or those that are having concerns with that, that would help us as a staff to be able to know where those problem spots are. And then I'm certainly happy to, as I know the planning public works director is, to reach out to the company, the owners of the companies. And I don't know all the companies that are working, but yeah, and I don't need to name them, because I don't know anything yet. So I'll certainly follow up with you on that and see if we can communicate with them and let them know the concerns more than maybe what they've known so far. I don't know if there's anything we can do. So.
From what I understand, I don't think
yeah.
And I would like to say, I guess what I'd like to say to people is, there's nothing to see. It's supposed to be, I don't know. It's, even though we may not have a dog in the fight, it reflects on the city of Ozark.
It does.
The reflection is that the city of Ozark
doesn't care.
Well, I think there's a huge level of confusion. I think, and I've been up there and I've been through Rolling Prairie, and Rolling Prairie is torn apart. It looks horrible. I know if it was me, I would be upset, wouldn't I? I mean, Mr. Parsons knows how I get upset about mine. But they're digging and boring is extracting a lot of rocks. And when they're going back and cleaning up, those rocks are still there. Well, that's not how they found it. That's not how the company found it when they decided to go through and do this. And we should be putting it back, or they should be putting it back the way it was, if not better than the way it was, but worse. They have gone even just over here by the swimming pool on 7th Avenue 4 or 5 months ago and did the same thing. And you can go over there and you can look where it's still torn up. There's rocks on the surface. There's no grass was ever seeded. I don't know that they ever put straw down. They may have thrown some seed down, but they didn't straw it. And so we've got to try to figure out through conversations with everybody involved in this, how we can, because our citizens deserve better than this. I mean, they just do. And I wish there was something we could do to facilitate this other than just have a conversation. But I think we definitely have to have some kind of conversation with anybody that's doing business inside the city, because they're harming our citizens.
I think that it probably goes back to the conversation that Alderman Flores has brought up before, and maybe that's what he's getting ready to say, is that, in the city of Ozark, there is no, we may not be able to permit this. I mean, it is a utility. It's considered a utility. They're working in the easement. We are right. We're very limited. But knowing who's doing business in our town and knowing the quality of the business that they're doing could probably be helped a bit with having contractor registrations in the city of Ozark. We do not have that. So just because you're a contractor doing work in the city of Ozark, I may not know that you're doing work in the city of Ozark, because you never have to come into the city of Ozark and even tell us you're conducting business here. Now, I'm not saying to try to, I get it. It doesn't mean permitting. Permitting and registering are two completely different things. We may not be able to require a permit for the work being done, but you would have better information of the contractor, the contact information, where they're located, who they are. And sometimes that's the biggest challenge, is we may not even know the right person to contact to even be able to address the situation, because we don't know who they are. Anyway, I may have stolen your soapbox, and I didn't mean to do that.
That was actually not where I was going, but I obviously agree with that. I think it's important to know who's working in your town and making sure that not just the people that actually live in our town and operate out of our town has to register, but people coming in as well. That would be, I think, the right way to go about it. But what I was going to ask about is these contractors, and we've talked about this one up here in particular, but I'm imagining, I guess my question is really, there has to be something somewhere that when they are allowed to work in these right of ways, which I get, we don't get to regulate that. So that's out of our control in that way. But I wonder what kind of regulations there are according to working within those right of ways that someone has put on these contractors. And the only way I can really think about going past this point where we may not have, any leverage on it, does anybody somewhere, surely there's some sort of rules they have to follow to use those right of ways. And I'm just curious if there is anything, and if so, if we can't use those as the leverage we need, if they're not being compliant with those. And that would be the only thing that I would like to go forward with, just to see if maybe that can be something we can use.
Utility easement, yeah.
Is that? Are those two phrases interchangeable?
I don't know. I think the question you're asking is for maybe staff to go back into the state law and look to see just when they passed a lot of new legislation in Jefferson City and deregulated or said that the cities are no longer allowed to regulate this, it's a public utility. What authorities did they take away from the local community to be able to police this type of a situation? So we can certainly do more research on that and find out, because there may be, and I do believe that in the legislation, there was language, I don't know to what extent, of, repair and replacement and things of that nature. I'm just not familiar enough with it to know, but we can certainly do that research and find that out. Whether you're in the easement or the right of way, they may define that differently by law. I'm sure they do, but I don't know in the legislation if they bundled that together or not, so.
Because the city has already received that either in fee or through an easement, and then they are allowed by state law to locate their utilities in our right of way. And there are certain regulations that Mr. Childers identified that prohibit municipalities from unfairly or improperly regulating the use of that utility right of way. So we can certainly look into it and bring forward any of those laws that may address this situation.
Sorry, I'm filtering through, trying to get back to Mr. Gardner. I can only have so
Well,
many
I
people
think,
live
I
at
think
once.
Ms. Callaway just said what I was gonna ask her or somebody in staff to do, is to check and see if there's any recourse that the city has against the companies that are treating our residents that way. So that was all.
Good. Any other questions? One last time. Comments, concerns, members of the Board of Aldermen? Mr. Galloway makes a motion to adjourn, I'm sure. He usually does.
Second.
This is the time when Mr. Galloway and Ms. Alder step forward. All those in favor? We are adjourned. Have a wonderful evening, everyone.
Get up a little bit.
Oh, my goodness.
I guess you kind of answered it for me, still a little stiff.
Building point.
Feel like it's getting.
It's out there.